My name is Paul Chmielewski. I oversee estate planning services for Cerity Partners. And my background, just a little bit on that, I'm an attorney by training. I have my law degree. I've got what they call an LLM in tax, which is a specialization in tax law. Practiced law for about 15 years. And then for the past 15 years, which, it's kind of scary that I've been doing this for 30 years now, I've been working with clients in the wealth management space on their estate and wealth planning needs. So today we are very lucky to have Peter Wayne with us. Peter is with Advocacy Trust. He's their general counsel. He started out in the special needs planning area as an attorney when he got out of law school. And now he is with Advocacy. And although they do have a specialization in special needs trust, they cover a broad gamut of trust administration issues. So thank you for being here, Peter. Advocacy is one of the companies on our approved list of third-party trust companies. So that means they survived a pretty rigorous internal vetting process, and we're very happy to have them as a partner. So Peter, why don't you give us some background on Advocacy and what you guys do?
Thanks, Paul. It's first, I just want to say it's an honor to be able to have the conversation with you today. I think this is an area, special needs planning, that is very important to me personally, but I think has been the bedrock of the Advocacy Trust since its initiation when it started back in 2015. And, I think you identified the great partnership that is developing between Cerity Partners and Advocacy Trust. And I think that stems from just, independently our commitment to making sure that we are representing the interest of our clients and then finding the best partners to satisfy whatever those objectives might be, whether they be investment related, fiduciary related, or in some combination trust and investments. So Advocacy Trust started back in 2015, in part as a subsidiary of an institution called the Forge Companies that has been around handling settlement planning work, primarily dedicated to the disabled demographic across the country. But the vast majority of those cases were coming from litigation. So somebody who was involved in some unfortunate set of circumstances that gave rise to a verdict, a judgment, or a settlement, and dollars had to be managed on account of of that outcome. What we found as an institution is that over many years, there weren't a lot of trust institutions that were willing to manage special needs trusts. And so either we were smart or not, we wanted to go and set up our own trust dedicated to going and serving that very demographic. So we were fortunate enough to be able to work with the state of Tennessee, which is where our state charter is from, to set up Advocacy Trust and dedicate primarily from its initiation a pretty healthy focus on serving individuals that were involved in litigation or families that had some form of disability, a disabled family member, and educating them about how special needs trusts can be a critical financial tool in the planning to help that disabled individual create a financial foundation and a structure around them to make sure that they get to maximize their quality of life. And, I think as you and I have gotten to know each other, I think we started to see that the core of who we are as a trust institution, while we started in the special needs space and have started to evolve into some maybe what I'll call more personal trust-related administration, it still comes back to that we are dedicated to serving a very needy demographic. And I think it's the core to who we are, and we look forward to not only this conversation, but being a great partner to Cerity and your advisors across the country who may have disabled individuals inside of their own book that could benefit from understanding the special needs tools that are out there and how to set up those family members for success long-term.
Yeah, I mean, that's awesome. Special needs is a very niche area, I guess you could call it. And there's a lot of need for services in that. Now, you mentioned you started as a special needs trust company, but you've evolved way beyond that. So it can kind of give us an idea of what you guys are doing these days,
Sure.
In addition to special needs.
So I think it's an interesting, you say a niche. I don't think anybody would wake up at age 18 and say, what I'm going to do for a living is I'm going to be a special needs lawyer. I don't think generally that happens. Much like you, I went to law school and had a pretty early focus on dedicating my career to serving the disabled demographic. But again, I don't think that is necessarily a common practice. But it is something that I think we take a lot of pride in. And we recognize that there was a void in the industry where people were committing to serving individuals with disabilities. And we realized that as we got really deep in terms of our ability to manage through special needs related planning matters, we learned that that white glove or very tailored approach to helping individuals in the trust space could navigate and be leveraged to be utilized in the retirement space, or for business owners who are looking for potential ways of maximizing the sale of their business or what have you. And I think that the reason for that is when you look at special needs, more often than not, that demographic sets up a trust largely with the idea that they're going to need to utilize those resources pretty much from the onset. It's not a, hey, we're going to put a bunch of money in a trust and we're just going to let it sit for a decade or more. Generally speaking, those resources are being deposited into a trust with the intention of leveraging certain laws that I think, as we'll get into in a little bit, I can detail, that allow for assets in a trust to not count against that individual's eligibility for certain government programs such as healthcare, Medicaid, Medicare. But also, too, we learn how to navigate the daily needs, whether it's healthcare or support or what have you. There's a constant communication between the trustee and the trust beneficiaries. And the fact that we were able to navigate that and set up a structure that was successful, I think, lend itself to talking about other opportunities, other areas where individuals such as business owners or high net worth individuals or family members who are looking at maybe trying to transition wealth from one generation to another may not present as a disability scenario, but there may be other factors where that more tailored, what I'd say, white glove approach to administration is a valuable resource in the overall planning strategy. And so we've seen an uptick over the last, I would say, 5 years, especially as we've developed our relationship, as an increased opportunity for us to take our dedicated approach of serving the beneficiaries and leveraging it to be tailored to, again, to reiterate, business owners who are looking to sell businesses, maybe in a tax advantaged situation, or individuals that may not have disabilities, but maybe have some form of addiction issue that we want to make sure we protect against, so that the assets from one generation to another aren't just automatically going to that generation, but that there are parameters and structures in place to ensure that those proceeds can help those individuals, but not place them in a scenario where maybe they make unfortunate choices that could be harmful to their interests.
Yeah, I think you're very right in terms of the relationship aspect, whether it's special needs or any trust relationship. Being able to deal with beneficiaries and accommodate their needs in a professional yet accommodative manner is key. And we appreciate you guys have been working very well with our clients in that respect. Now, today we're focusing on special needs trust planning, and special needs. What does that mean?
So I think it's a term that I think if anybody has an individual with a disability inside their family, I think it encompasses many different aspects. But I think for the practitioner who may be listening, or for the potential client prospect who may be listening to this presentation, it really stems from a scenario where you've got an individual, either who they themselves have either received an inheritance, or that or mom and dad are trying to strategize over how to take generational wealth without negatively impacting the interests of that particular family member. And those special needs scenarios could be that maybe they've got some form of a developmental delay, or maybe they have some form of, physical disability or physical limitation. They've got some sort of maybe, brain injury, unfortunately, occurring from a sports incident or a work incident. Any number of factors could come in. Unfortunately, a lot of times, many of these special needs scenarios arise from actual accidents, car accidents, tractor trailer accidents, other workplace incidences that are debilitating to a particular individual. Those special needs factors present us with an opportunity to say, okay, let's stop and think through, what is it that we're actually trying to solve for? Maybe there's an inheritance that is coming from a family member. Maybe it's litigation proceeds that we're trying to figure out, what do we do with those resources to leverage them in a way that's going to augment that person's quality of life, but at the same time not negate their ability to access certain government programs. So as way of example, maybe Paul, just for those in the audience, there are really two different forms of government assistance in this country. There are what we call entitlement benefits, and there are benefits that are means tested. When you fall into the entitlement scenario, there's going to be benefits that are largely Medicaid and supplemental security income. Those are predicated on an income and an asset test. As a general rule, Medicaid is not provided to the general public, more unless you're in some of an expanded form of Medicaid, which maybe it's time for a separate discussion. But as a general rule, vast majority of Medicaid dollars are provided to the elderly, to children, and to the disabled community. And that was its primary focus. But in the disabled community, the way you become eligible for the program is more often than not throughout the 50 states, you are eligible for supplemental security income, which is an income assistance provided to certain individuals who have a form of disability. In other words, they can't go perform gainful, substantial employment. They can't go work. They can't go to school. They can't do certain functions, or at least their ability to engage in those activities is very limited. And as a result, they're eligible for an income stipend called the Supplemental Security Income Benefit. Right now, that benefit in each state, I think, is $984. And as long as you get $1 of SSI, you would be eligible for Medicaid through the vast majority of the United States. Kentucky, I know you're in out in Colorado. Those are two states that both apply that way. And when you're eligible for SSI and Medicaid, those benefits are supplementing the lifestyle of that particular person. But if you're getting an inheritance, or you have some other form of income that maybe or asset that becomes available to you through, say, for example, litigation, that those benefits are not only predicated on income, but there's also a $2,000 asset limit. So if you have a windfall of some kind, and you may be on a Medicaid and an SSI benefit that's producing stabilization in someone's life, that inheritance, that windfall, if you will, could be very detrimental to the interest of that particular beneficiary. So as a way to protect against that is you put the special needs trust in place as the sole recipient of those resources. And there's really two different ways that those apply. One is through first-party special needs trusts. Those first-party special needs trusts are designed to be able to take the assets of a person, say, from litigation. If I was involved in a car accident and I settled a case and I was on SSI and Medicaid and I wanted to preserve my eligibility for those programs, I would set up my own first-party special needs trust that would be utilized to be able to receive those litigation proceeds and administer it in that vehicle. And as so long as the trust is drafted for the sole benefit of my interests, that I am the only one that can benefit from them, and additionally that any assets at my death, that when the trust terminates, goes back to reimburse the state for any Medicaid dollars paid on my behalf, those being the two primary provisions, those assets in that trust are not going to be counted against me for purposes of eligibility for SSI and Medicaid. So now I've got that pool of resources in that bucket that you're the advisory team that you work with can invest and make sure grows and substantiates the needs that I may identify over long time periods. But I've also got the SSI and I've got the Medicaid. And frankly, I think to many of those in the audience today, it's really the Medicaid that is so critical to the viability of that particular person's healthcare. Because by losing the Medicaid, you then are going to be looking at oftentimes scenarios of trying to go out of pocket for most of that care that would be cost prohibitive and would wipe out all of the resources potentially that are in that trust. So by leveraging the special needs trust and maintaining your eligibility for Medicaid and SSI, you're kind of creating sort of if you will, a triangular solution of being able to provide a financial foundation for that individual to be able to go and live upon. Let me pause there for a second and see if the first-party trust description I made makes sense to you.
Yeah, no, it makes perfect sense. I appreciate your distinguishing between the two, because I think for clients that becomes confusing. This is not a easy area to understand, and there's a lot of technical requirements that have to be met. And so there's a big difference between somebody leaving money in an inheritance, which I think you're going to get to in a second, versus getting a judgment or having money in their own name, which would disqualify them from government benefits, right?
That's correct. Yeah. So on that end, I think for your audience, that first party scenario is probably more limited in its the volume of opportunities inside of maybe their lives that may be presenting a scenario where you need to set up a first party trust. If you have the opportunity to do the third party planning with your clients in advance. In that third party planning is really driven by mom and dad or aunts and uncles, whomever, but let's just focus on mom and dad. So, in my scenario, I always try to describe it the best way I can, which is if it were my own children. So if, my wife and I, we don't have a lot yet, but hopefully someday we do. We have an estate plan put together. that ultimately is going to be the recipient of a bunch of assets upon my wife's and my ultimate demise. And those assets are going to be held in trust for the benefit of my two children, Molly and Henry. At some point, those trusts it's a pot trust until they get to the after college, because honestly, my wife and I have one account we manage all the resources from, and that's where they operate out of. So if we were to go away, a guardian or whomever we're taking care of our children, we would want that same structure in place throughout the totality of their youth on in through college. And after college, then we would divide up those assets equally between the two of them, and then they would have the ability to have a trust continuing to support their needs through their younger adult years. If, however, either of them were to become disabled at some point, we could adjust the current strategy so that it wouldn't just be, as I described you, a pot trust, and then ultimately what are called health, education, maintenance, and support trusts for our two children. We would actually have one of the trusts designed as a third-party special needs trust. And in that third-party special needs trust, that actually we would set up as its own standalone trust. So in the example I was giving you before, the trust that I've set up for my children and my wife has got a mirror image of it, they're called revocable trusts, meaning that during the course of our lifetime, we have the ability to go and adjust the language of those documents as we seem and deem necessary. We can change it as many times as we want until we either become incapacitated or we become deceased, at such time that they become irrevocable. But in the example where a special needs component is applicable, I would have changed that strategy to a degree. I would have the revocable component of that, where a document is setting forth how the trusts will operate in the event of certain deaths, ultimately to my wife and then ultimately to my kids. But in the special needs child scenario, I would actually set up its own standalone, irrevocable special needs trust. And by doing that, I would then direct any resources that would ultimately become viable or available to that child through inheritance or otherwise on my behalf or my behalf of my wife. We would direct that not to the revocable direction that we've created, but actually kick it out to that trust that we have set up for the benefit of that disabled child. The reason it's a standalone vehicle is because we think it's advantageous that not only that we get the benefit of being able to do it, but if there's anybody else in our family, aunts, uncles, or cousins, all my grandparents are long deceased, sadly, but if any of them were available, or for those that may have them out there in your audience, some of them may have intentions that are very, very positive in nature, right? They're going to leave assets to say my example, let's just say it's Henry, and Henry was, present to some form of disability. Somebody may want to leave assets to him as a way of being able to provide support, but without thinking and understanding how a particular unplanned inheritance may impact the SSI and Medicaid I was talking about before, we've now got a scenario where that desired sort of support that was given now creates negative outcomes, right? We would lose the Medicaid, we'd lose the SSI, and we'd have to deal with the ramifications of that and largely have to move it into that first-party trust scenario that I was describing earlier. Because those assets that would come from somebody directly are now the assets of that particular child. And so the only way to be able to keep eligibility in place would be to make sure that that first-party trust is now the owner, or transfer those assets into that first-party trust.
Peter, can I ask you to clarify something? You had said you wanted to set up this separate standalone trust. Is that a separate trust that's created all by itself, or is it created by your revocable trust?
It's actually created all by itself.
Okay.
So for those in the audience, when you think of trust, I often try to think of them as a box. And, think of it, the box is the trust, and the trust agreement, which institutions like Advocacy Trust would be asked to manage. We're told what the rules are for when assets can go in and out of that box. And in an irrevocable scenario, we would be the ultimate party responsible for taking what is this separate and distinct box that is already set up for the benefit of the disabled child. Once it's set up, though, the terms cannot be changed. We've set it up purposely to be able to protect against any negative and ramifications of an inheritance coming to that child. So assets would come into the trust from either the parent, grandparent, guardian, whomever, and those assets now are going to be managed very similar to that first-party scenario, first-party special needs trust scenario. They're going to be managed to be able to provide for the continuing needs of that disabled child underneath the sole discretion of the trustee. So we as trustee, if we were hired, we would have sole discretion as to how those assets are going to be utilized. And so long as we structure that right, we then have protected against any negative outcomes that may occur with respect to eligibilities for Medicaid and SSI benefits. So we've given a sort of a pot, if you will, for people to utilize, free and separate and apart from the planning that my wife and I may continuing to do underneath a revocable model.
A lot of people say, oh, I'll just go to my estate planning attorney. They know about special needs trust planning because they're an estate planning attorney. Is that true in a lot of cases?
I think generally this is a little bit of a specialized area. And, I think you'd want to make sure, much like you vetted us, to make sure that we understood the differences in how special needs trusts are administered. If you were, a high net worth individual that was looking for understanding of charitable remainder trusts and how those are to be administered and the reporting requirements that may be necessary to the IRS and other beneficiaries, there are distinctive parts to that administrative responsibility. Similarly, in a special needs scenario, there are obligations that we're going to have to courts and to Medicaid agencies and to the Social Security Administration, a world that we live in with regularity that becomes second nature to us. But we've learned that over time. In that same respect, trust attorneys have that same level of, regularity. They have comfort in maybe a specialization. So whenever going out to talk to your particular, if you're a protective client, you got your own trust attorney, I would just talk to them about whether or not they have comfort in this particular area and understand about whether or not they understand the ramifications of this type of planning and how to implement it properly. I think the other scenario is, if you don't feel like you have a great resource, I know, Paul, you and I have talked many times about the networks that we have access to. I'm sure many of your advisors do as well, of understanding that there are attorneys out there. A great example is the Special Needs Alliance. If you actually Google Special Needs Alliance, it is a listing of attorneys in each state that specialize in special needs related planning matters. In that sort of a component, you've sort of got a pre-vetted list of attorneys who can help navigate the planning strategies that we've talked about. So
yeah,
I think
I just wanted to make sure people realize that just because, and most of the state planning attorneys will be pretty upfront with you, and they'll say, listen, they may understand special needs, but a lot of times it's not something they delve in a lot and they don't want any part of it. And they'll say, listen, you may need to talk to somebody else about that specific area. So it doesn't automatically translate. I just want to make sure people realize that. So
you're 100% right. I think and I think this is a great opportunity to leverage the relationship you have with your advisors in Cerity, is just understanding that if you don't have somebody, there are easy ways for us to connect you with somebody who has that particular skill set. As it relates to the actual administrative components of a special needs trust, as I said before, when you think of the vast majority of trusts out there, many of them have what is called a health, education, maintenance, and support standard. What does that ultimately mean? It means that generally speaking, a trustee is going to take on responsibility for administering a trust for a group or a singular individual to provide for things in their life that they may need. So educational assistance, tutoring, support through school, or access to certain camps. And the greatest example I can always give is, say, for example, a beneficiary turns 16 and they want a car, right? Under the HEMS standard, the trustee could look at that and go, given a dollar set in a particular trust, that's a reasonable thing to purchase. But we're not going to go buy a Ferrari. You're probably going to buy a used Camry of some kind at that point, right? It's all about moderation and helping the beneficiaries make informed and positive decision-making as it relates to how trust funds are utilized for the benefit of that individual. But that HEMS standard sort of sets the framework for how we utilize those resources. In a trust that is designed for special needs purposes, whether it's first or third party, the trustee has sole discretion. In other words, there's no scenario where we're forced to make a distribution. We are the final say as it relates to how those resources are utilized. But that's because the way in which the laws are written, that's a requirement of the terms of the trust document. In practicality, it allows us the discretion to make sure that we are able to deny requests that are unreasonable or that are going to come in that could negate someone's eligibility for government assistance. And we can support the things that are very critical to their well-being. So you might ask, what are examples of things that are really critical? Well, for many times disabled individuals, they need a home. If they're not going to be in a facility, they need a home, and they need that home designed appropriately for their needs. Wheelchair accessible bathrooms and showers and things of that nature. In addition, you're going to need probably a handicap accessible van. We've got relationships throughout the country of various modification companies and car sales organizations that are dedicated to serving special needs related interests. So we get to leverage that. We can also a lot of times make sure that healthcare is being paid for, or if a particular nursing requirement is needed or physical therapy is needed in the home, those are things that we're going to look to support as the trust is utilized for the lifetime of that special needs individual. In addition, more simplistically, it's like, we're going to be able to provide support for birthdays and certain limited vacations, and understanding that, vacations are hard, potentially for a disabled person to go on their own. So it's not just about providing the ability for the disabled individual to go, but for probably a caretaker, such as a parent or grandparent or something of that nature, to go as well. So I could probably spend the better part of a half an hour giving you additional examples of how these resources are utilized. But I think for the audiences, realize that you're giving the particular child or beneficiary the ability to maintain access to government assistance. And with the right trust beneficiary, our job is to make sure that those resources are leveraged to the greatest extent possible to give autonomy in that individual's quality of life. And as we'll get into in a few minutes, I'll give some examples, some additional partnerships we've developed that may be valuable to your audience.
Yeah, Peter, you make the distribution process sound pretty straightforward. Having said that, most trust companies are saying we want no part of special needs trust and we won't administer them. Can you kind of explain why they're doing that?
Yeah, I think oftentimes it's like anything. What you're uncomfortable with or you don't have experience with, people tend to shy away with. I think it was drilled in our heads during law school that, liability, you run away from it, so to speak. I think what we found is that it was an area that we had such great exposure to that it became second nature to sort of the foundation upon which we did our business. So we had to understand the eligibility rules for Medicaid and for supplemental security income. We had to understand that on the other spectrum, there are entitlement benefits like Medicare and Social Security disability income that are necessary and available to anybody who's out and had a long working history. We understand the distinction between those two programs, means tested versus entitlement based. For a lot of trust companies, that isn't second nature, right? They understand the distribution process. They know how to maybe do the tax reporting that the IRS requires, but they're not comfortable in the areas that are more government benefit related. In our experience, that's okay. I think, if anything, we've seen even the law profession become more and more segmented into various areas of sort of technical expertise. And as institutions have shied away from maybe focusing on special needs related matters, we've sort of seen it as an opportunity to say, okay, then we're going to go do our best to fill that void. So where others run away, we see an opportunity to sort of supplant the marketplace.
Yeah, I think you deal with it every day, and so it's second nature to you. But when you start talking about eligibility requirements for Medicaid, Social Security, you name all these different programs, you can see it is a complex system. You better know what you're doing. And there's a lot more than just saying, hey, there's this distribution standard we've got to pay attention to. And, we've got a lot of leeway in that distribution. You have government regulations that you have to comply with too, which makes it more difficult. So I think you guys are doing a much tougher job than you give yourself credit for.
Well, I think you'd said at the beginning, that you'd referenced my title. Unfortunately, I've had an opportunity to continue to grow, and I think we as a company have continued to grow, and we've hired a lot of lawyers who actually do a lot of our legal work now. So fortunately, Paul, at one point I was doing a lot of our legal work. I've now done a lot more of the relationship management work that you and I get the benefit of participating in. But I think it goes to show that as you hire really talented people, which we've been fortunate enough to be able to hire, that are dedicating to serving this demographic of people, it's pretty enjoyable, and it's very rewarding to sort of participate in being able to not only serve and develop a company that you're proud of, but at the end of the day, you actually go look at your primary source of clients and recognize that you're doing an incredible service to them to the best of your ability. We're not perfect. We will always make mistakes. But I think we are dedicated to always trying to do the right thing for the right reasons, and it's a very rewarding experience for us.
That's great. Let me ask you a question. We talked about special needs trust, but there's, I want to say relatively new, because it's been a while, but it's a relatively new entry into the special needs planning space, and that's ABLE accounts. Can you explain ABLE accounts and what role they play in the whole process?
Sure. And I'm actually I'll take that. And I'm gonna delve into some of the other examples of some related administrative tools that I think your audience may value. When you look at the eligibility rules for SSI and Medicaid, again, it's a income threshold. I think again it's $984 I think per month, and then there's a $2,000 countable resource, meaning you can have no more than $2,000 in say a checking account or a CD without negating your eligibility for SSI and Medicaid, and that verification happens month over month. So if you have at any given time period for month over month more than $2,000 in countable resources, you've now negated your eligibility for those programs. And I think, as just the inflationary, matters have increased, that number hasn't changed. but the vast majority of dollars, when you're getting from the supplemental security income statement, you're getting 984. If you had, say, 2 or 3 months where you just didn't have a lot of expenses, you've got nowhere to go. You've now got more than $2,000 in countable resources, and it was creating eligibility constraints for the disabled community throughout the country. In response to that, there was the ABLE account law that was passed, I believe it was in 2014, that allows for individuals who have a form of disability prior to the age of 26 to set up effectively what is a checking account. Now, you can't go to, PNC or Huntington Bank or Bank of America or, any of the national banks or community banks and set one up. There is a particular account in each state. Many states call them stable. That's STABLE. If you actually Google stable, you will see it pulled up. Kentucky is a good example. We have the Kentucky Stable Account Program that is actually administered in part through, I think, the Department of Revenue in Ohio. They created the stable program and then they leverage it out throughout the country. But think of it effectively as a checking account. It's just run through a particular program. I then can add up to, currently based on the gift tax return, the annual gift tax exclusion, I believe is 18,000. Correct me if I'm wrong. Is it 18 or 19?
19,000 this year.
Yeah, okay. So it's 19,000. So now I can add $19,000 into this account for the benefit of if I was disabled, my own interests, or it was for my child, I would put 19,000 into it a year. And I don't have any issues at all as it relates to, maintaining eligibility for means tested programs like Medicaid and SSI. And the beauty of this particular program, you may say, well, why do I need that if I have a special needs trust? Is the special needs trust is a third party, such as us, is going to be administering how those assets go in and go out. But we also oftentimes are overseen and audited, if you will, by either a court, if that's the institution overseeing us, or the Social Security Administration. They care, and they are going to give us an annual assessment a lot of times about our administrative practices inside that trust. An ABLE account, on the other hand, is actually established as a 529A of the Internal Revenue Code. Many of you all may know 529 is the college savings account. So it was designed to sort of complement the 528, 529 program and allow for individuals to set up these accounts, which means the IRS actually oversees their administration. Effectively, they don't know what to do with it, so there really isn't very much oversight per se. And those assets have got a much broader utilization tool. So you can pay for things relating to food and shelter and any academic needs or healthcare needs. All of those things, you can pay for out of the ABLE account. And again, it's not going to disqualify you at all from an SSI or Medicaid standpoint. So let me pause there and see if we have any questions. And if not, I'm going to tie that into the trust administration for a second.
No, I mean, I think you're probably going to go to this place eventually, if not really soon. But, when you mentioned earlier, okay, if your caregiver wants to go on vacation with you or something like that, we often see caregivers as family members in these situations. Mm-hmm. And I get asked a lot, can a family member serve as a caregiver? First of all, obviously they can they get paid for it? And how do you go about doing that when you're hiring people to assist special needs people?
One simplistic way is you could potentially do it through the ABLE account. If it was a nominal amount of funds per year that needed to be utilized. When you look at the trustee, our job again is to make sure that we administer the trust to keep the individual eligible, and to then honestly leverage our experience and our knowledge to make that life even better. So I'll use the ABLE account, and then I'll continue to build the answer directly to your question. we use ABLE accounts a lot. Even though we ultimately are the trustee, we push money out into ABLE accounts where we think that the appropriate structures are in place to protect the interest of that particular beneficiary, because it gives them autonomy. Our greatest job is to give the life and the quality of life to that disabled party, the greatest quality of life we can. If they don't have to come to us for every dime, that's a good thing. That's a value add. They've got more autonomy. In addition, if we pay for things relating to food and shelter out of the trust, they're going to lose some portion of their SSI. They call that in-kind support and maintenance. And so their SSI check may be reduced by the Social Security Administration up to a maximum of 1/3 per month. If we do that same distribution, but we kick it to the ABLE account, and the ABLE account were to ultimately make those purchases, there's no impact to the SSI at all. So it's understanding how all of these pieces work together. As a direct example of what you've now talked about, is we use a lot of times an organization called Team. They're out of California, and that organization has a particular program where the trust can actually go to and employ family members to provide care management. You may say, well, why does that matter? Well, the high majority or the vast majority of individuals that have disabilities of some kind often require one of the two custodial parents to ultimately maybe limit their professional growth to care for the needs of that particular child. And by doing so, they're limiting their economic viability of the home. And so the job of the trust is to say, well, could we supplant that in some form? This isn't going to be available to every trust out there because there's certain income limitations that, or rather, not income limitations, but the size of the assets in the trust just may not justify it. But if there's enough resources to underwrite the costs associated with helping provide continuing financial supports of the family, allow for that parent to then also get insurance, through healthcare insurance, which is a viable opportunity inside this program, as well as set up as a 401k program. All of that can be done through Team. We've seen great success because it allows the parent to focus on the most important thing in their life, their child, without completely sacrificing the economic viability of the home. And we have found the more financial stability you give to the totality of that household, the greater the success is for everyone. If that's not the right arrangement, we work with a large majority of outside providers, national care advisors. There's Broadspire. There is diversified nurse consultants. There are organizations out there that provide nursing assistance, rehabilitative assistance, that the trust could then pay that third party to pay for the care needs of that particular child. So it's understanding all about those pieces and how the various experts out in the fields are able to be leveraged to provide the greatest outcome.
Yeah, I think the danger, because some people say, why wouldn't the trust just employ that person directly? Why would you use Team? Just keep in mind, if you employ anybody, all of a sudden you're subject to employment issues with, if they have, if they get hurt, unemployment comp, all those sorts of things. You got to start doing your own tax reporting, self-employment tax, all that sort of thing. Team handles all of that for you. They basically step in the shoes and become the employer and handle all those issues for you. My family used Team when my mom, unfortunately, who's passed now, she passed away. We used Team to avoid all that potential liability. Said, Team, that's you. We'll pay you for that, but we don't want to deal with all that potential liability and all that work. So now you mentioned ABLE accounts also. You have special needs, you have ABLE accounts, and there's another type of card that I know a lot of times is used to pay for things. Can you explain that?
Yeah, and I hope there's a theme here to a degree. Is if you hear anything out of us, is that it's really, I always say it's being able to give autonomy to the individual to the greatest extent possible. And so whether it's an ABLE account, it's Team, it's the trust in way that we just provide support. It's again all trying to get to some level of autonomy where they're not feeling like they've got to come to the trustee for every single decision that is in their life. And the TrueLink card that you're now referencing a great example of that. So TrueLink is effectively a debit card that is tied back to the trust that we as the trustee then to control where or how many assets are put on there at any given time, and then point of sale. It will say, all right, in funding that card, let's just say again, if it was my daughter, and say my wife and I are both deceased. My daughter's disabled. She's got a guardian who's overseeing her, and she's got a trust fund. That guardian then could take that TrueLink card and go to the store and buy, diapers or healthcare or prescription drugs or go to the movies or go to a basketball game or do certain things that the trustee would say, yeah, that's pre-approved, you can go do that, and without coming to the trust for prior authorization. It's giving them some, again, level of autonomy. However, we would restrict the ability for that card to be used, say, for alcohol or tobacco or other, maybe unnecessary items that we would think is, they'd rather us come to. Say, for example, we don't want them buying tires because we don't want them buying tires and putting them in the car that may not be the right designed for that particular, vehicle. So we would say, you know what, no, we're not going to allow vehicular purchases at all. We're going to control that and make those items. It just gives us some level of creating autonomy without, ultimately acquiescing to the interests of that person in totality, if that makes
It
sense.
also helps you control and make sure they're not violating the government restrictions on what they can pay for, right? Okay.
Correct.
So that's great.
Yeah.
Now, we've got not a ton of time, so I just want to hit some highlights. You guys are chartered in Tennessee.
Yeah.
So you're a Tennessee chartered trust company. Can you tell us why you chose Tennessee and how that allows you to work with clients around the country?
Yeah. So I think, when you think about why we chose Tennessee, the history of our organization has largely been through the footprint has historically been, sort of the southeast up and northeast and up through the northeast corridor. And Tennessee allowed for us to be in that same general region. At the same time, there are asset protection laws that are unique to the state of Tennessee that we wanted our beneficiaries in the disabled community to be able to leverage. So when you think of trusts, again, if you're, for the audience out there, think of a trust as a box, right? You put money in it and the trustee is responsible for deciding when assets come in and come out of that box. If I set up this trust for the benefit of my children, that box, if it's my money and I'm no longer here and my assets are now in there and my children are benefiting from it, there is asset protection. In other words, those assets are free and clear, generally speaking, from divorce proceedings, from liability, from bankruptcy, for things that, because those assets are never truly my children's money, that money is the trust's resources, and the trustee decides when and how those assets are made available to the benefit of those children. In Kentucky, and you can clarify if it's true in Colorado, in Kentucky, you can't actually set up I couldn't set up a trust for myself and put money in it and then have that same asset protection made available to me. I can't. The way that the laws would look is they would think that those assets in that trust, because I set it up and I'm the beneficiary, they would see that as assets that are subject to divorce and liability and bankruptcy and other aspects.
Yeah, there's a select amount of jurisdictions in the country that allow for you to be a beneficiary of the trust while still getting asset protection, to be exempt from claims by people trying to get the assets. And we identified certain jurisdictions, and those are the places where we went and chose trust companies to work with because of those protections. In Tennessee, most people historically hadn't thought of it, but Tennessee has really done a good job in strengthening those protections and is now one of the better jurisdictions in the country for that. So now, does that prevent you from working in other states, especially special needs, which is largely has a lot of state-specific issues that have to be dealt with?
No, I think it's a twofold answer. So, even though if we wanted to take advantage of the asset protection laws that are unique to Tennessee, then we would have that trust be a Tennessee trust, and we would administer it from our office in Brentwood, Tennessee, just south of Nashville. That's the way in which the laws of Tennessee require it. However, if it's a general, what I talked about before was a health, education, maintenance, and support trust, or it's a special needs trust, it's in Alabama, it's in Milwaukee, it's in Arizona, wherever the particular case may be, we can either do one of two things. Either in I think it's 35 states that we now have reciprocity in, which means that we as a trust institution have a charter in the state of Tennessee, but a particular state allows us to do fiduciary work in that state, largely because we have submitted certain pieces of information to their financial regulators to give us authorization in that state. I would either use that vehicle by which we would administer it in that particular state, or alternatively, we would just situs the trust administration in the state of Tennessee, meaning all the administration would occur in the state of Tennessee in our Brentwood office, and the laws may still apply to a particular jurisdiction, whether that's, say, for Virginia, or it's in Arizona is another state where we don't have reciprocity. We would just move that to Tennessee so that we're able to provide services to the totality of your advisory footprint So no, it is not a limiting factor. It's just a component of the planning process that we have to navigate.
Yeah, and I think I would just mention that that's pretty standard because there's a lot of trust companies are state chartered, and that's going to be the same issues will apply to any of those trust companies that you have to deal with. So, no, I appreciate that insight. Is there any other services? I mean, we talked about special needs, but I just want to close real quick because I know you guys are a full service trust company. What other interesting things are you seeing out in the environment today that clients are making use of?
Yeah, I think I'll start just by the most simplistic, and I think this is where I hopefully for your audience, whether you're a potential client, a client, or just an advisor, is really hone in on just the generational wealth transfer. So, again, I use myself as an example, but when you have assets, and again, my wife and I don't have many yet. Hopefully, we get more of them as we continue to aspire into our professional careers. In that model, we've got life insurance. All right, so we want to make sure that our children at age 18, we don't want them to have a windfall of any amount that could compromise the decision making that they would make at their young adulthood. So we have trusts in place that are designed to be the recipient of any assets, including life insurance. And then, as I talked about before, it's a pot during their younger years, and then as they get older, they would divide into separate trusts, and those trusts continue on. We, as a trust company, we oftentimes are the trustees designed to administer those trusts. There's no special needs or addictive issues or anything of that nature. It's really just the mechanism by which one generation is able to pass wealth to another generation without that money being ultimately made available to that child at age 18, right? I think, Paul, you and I have talked openly about the fact that, we probably would have made some relatively poor decisions if we had had significant wealth at age 18. And if I had been given that opportunity to sort of continue to grow and mature, that the decisions I make at 35 would be very different at age 18. And that's the idea behind it all, is that even if there's no addictive or other issues involved, it's just a matter of giving your children from one generation to another an opportunity to find success. And we can provide that service, please.
Yeah, I think that you make a good point because the intergenerational wealth transfer is such a huge issue. And you're not certain when you transfer wealth whether there will be a special needs issue. You don't know what can happen down the line. Right. So the ability to add that component in as a contingency planning factor in the whole process, which I think is kind of what people want. They want to make sure not only are they passing it on, but doing it in an efficient way. And we didn't cover this, and we don't really have time to do it, but make sure your plan is cohesive, right? Because you can have an intergenerational plan, you include special needs planning on there, but let's say you have a big IRA and you don't think about, oh, well, I'm just going to pass that out to my kids. Say one of those kids is disabled, all of a sudden you've disqualified them from the government benefits that you want them to have. So it's a very holistic overview that you got to make sure you're taking care of.
I think as we get close to the end here, I think the thing I would for the non-advisor audience is talk to your advisor regularly about this. And if they don't have a copy of your documents, please give your documents to your advisor. It's probably one of the most valuable things that your advisor can review for you to make sure that their financial plan and the estate plan mirror one another. Because as you just identified, if you have an IRA that is going to go to your estate, you have everything else going in a particular estate plan, well, this estate plan may not necessarily accomplish the goals that you desire. Having those interwoven together in working with your advisor to regularly review those documents is critical.
Yeah, I mean, that's kind of what we do on, in my department. And I think it's very valuable because just having a standalone trust without considering everything else that's going on, you haven't done the client the overall planning process the right way. You really have to look at everything combined and how it all works together. And I appreciate your time today. I will mention this, Peter and Advocacy have been great. We've had presentations we've done on this topic and some other topics that people have said, hey, that's really great. And we'd love to get you in front of this organization or that organization because they need this kind of information. So I just want to throw out there, it's always open. It's always an option. If that's of interest, that you have an organization that you think would benefit from it, just let us know. Just contact your Cerity Partners planning team. If you have any questions, they can help you and lead you in the right direction and always bring us into the conversation if that's needed. Any last words, Peter?
Sure. Thank you. I meant a couple things. One is, we haven't had a chance to talk about it, but, obviously we have talked a lot about business succession planning and the way in which our trust existence, our trust charter being in Tennessee is potentially a valuable resource from a tax planning perspective. So I think if there's ever anybody,
Income tax planning perspective.
correct.
Yeah.
Yes.
There's going to be some very beneficial aspects to changing which state your business is owned before you sell it. Yeah.
As a great example, if we want to go into that a little bit deeper in another follow-up conversation, we'd be happy to do it.
Yeah.
Secondly, just, I think the important thing for your audience to know is just, we're grateful for the partnership with Cerity Partners, right? I think culturally we're very aligned, and that's a really unique thing to find. But I also would say that we recognize that you all do what you do so well, and you let us do what we do really well. And that's, I think, the sign of a really great partnership. And to the extent that we could be a complementary resource for the advisors or the audience, whomever it might be, please know we welcome any opportunity, regardless of whether or not it results in business, to just have the dialogue. Because every opportunity for us to talk through a particular set of facts makes us a little bit better at what we do every day. And we're very grateful for it. So I think I'll close by just saying thank you for the opportunity to come on this morning, or this afternoon rather, and talk through special needs planning. Clearly, I hope the passion that I have for it, which is true throughout the totality of our company, comes across as authentic, because it is. We're very honored to be able to do the work that we do every day. We're very proud of it. And if we can be a resource to you and the advisors, whether it's tomorrow or 5 years from now, we look forward to that opportunity, and just am grateful for the time with you this afternoon.
No, I appreciate it, Peter. You've been a great partner to work with as well. And we focused on special needs planning today, but so everybody knows, there's a ton of planning opportunities out there for estate tax purposes, state income tax purpose reduction on the sale of your business, protect your assets from creditors. There's all kinds of things out there. We touched on one topic and we barely skimmed the surface of that. So any questions, contact your Cerity Partners advisory team. Ask them if they need to. They can bring myself or Peter into the conversation. We appreciate your time today, and have a great day.